Roland Mumford with Mumford.law. I want to speak with you about communicating accommodation requests to your employer and what you need to do to accomplish that. So if you're employed and you have a disability, and disability under the ADA is defined as a condition that substantially impairs your everyday routine activities. That could be insomnia, difficulty eating, difficulty taking a shower, walking about, physical limitations, and so forth. If you have a disability in the workplace and you require an accommodation, it is important that you communicate that accommodation request not only verbally to human resources or to your immediate supervisor, but also in writing, because very often in the disability discrimination cases that I handle regarding disability claims, there's always a question of fact about whether an accommodation request was in fact communicated. Once they receive that accommodation request, then the employer is required to do something called engage in an interactive process. That is the lingo. They have to come and speak with you, discuss with you the essential duties, job functions of your job, because that's what the law requires you to be able to do. And then they have to determine whether it is an undue burden for them to accommodate your request to perform your duties with your disability in the workplace. If you require something as simple as a special type of ergodynamic chair, a type of keyboard, because maybe you have carpal tunnel syndrome, maybe you need one of these types of things where you can place on your desk and it raises up and down so you can sit and stand because it's difficulty sitting for long periods of time, that is most likely going to have to be accepted by the employer and covered by the employer. However, where you kind of get into the mid-tier types of cases is where maybe you request to work from home, either full-time or a certain number of days a week. And that's really just fact dependent on your disability, the medical condition, and the type of duties that you perform. Now, if you get a letter from your doctor, which will absolutely help your case, where the physician puts you on restrictions such as no more than 5, 10, or 15 pounds of lifting, pushing, or pulling, depending on the job, the employer is going to have a hard time not being able to accommodate that. But in certain types of jobs, they may not be able to accommodate that. It just depends, again, is it an undue burden? And there's case law about what constitutes essential job functions, undue burden, and so forth. Then there's the more difficult cases. For example, if you're in a wheelchair and the building is maybe an older building and you're requesting an elevator to be put in, that's not going to happen. Always communicate that accommodation request to the employer in writing. If you're in a one-party consent state, record it.